Hello, I'm Chris Merritt, and with me is my colleague from the Rule of Law Institute, Sally Layson. And we're here with the newly installed Chief Justice of New South Wales, Andrew Bell. And we're here to discuss the rule of law, which is a subject close to the heart of all judges. Chief Justice, what's the health of the rule of law like in this country?
Well, I think broadly pretty good, but it's something which you just can't take for granted. I, in my swearing-in speech, made reference to a couple of examples from the United States in recent years with, for example, the appointment of a Supreme Court judge who was standing next to the president, and the president said explicitly, I expect her to do the right thing. I regard that as I said in my swearing-in speech, anathema to the rule of law and the independence of the judiciary. And what's critical, of course, about the rule of law is that an independent judiciary engages in appropriate judicial review of the executive and indeed holds the legislative in a constitutional system to the metes and bounds of constitutional authority. So my point about giving a reference to the United States is that the rule of law is such an important concept, but it's fragile. It can easily be corroded, and corroded quite quickly, and not only in authoritarian regimes, but in regimes in countries which are not necessarily all that dissimilar to our own. So whilst I think that the rule of law is a central component of Australian democracy, it's something that has to be requires eternal vigilance in terms of keeping respect for the rule of law prominent, in ensuring that society, not just lawyers, but society more generally, understands what we mean by the rule of law, and I might expand on that in due course, but has an understanding of what it means and more particularly why it's so important and central to a functioning democracy.
What are the benefits, not just for the judiciary, but what are the benefits for society?
Well, society, we can take for granted our relatively peaceful, law-abiding way of life. It's easy for us to become complacent and take that for granted. But as I say, it's a fragile thing. And it's important that people understand that one of the reasons we have a stable society is we have a system of independent courts who hold governments to account, holds the executive to account to make sure that they are acting within the proper limits of their authority, that we have courts where people will receive procedural fairness, where the decision will be made on the merits, and where there are rights of review by way of appeal or judicial review. It's very easy to take those things for granted. And so educating people about what we broadly refer to as the rule of law is important, because it means that people understand what binds the community together in a way which is not necessarily obvious, but is there as a constant in our functioning democracy.
In your first address as Chief Justice, you referred to the importance of education about the rule of law.
Yeah.
Do you think, as a society, we're doing enough to inculcate the benefits of this doctrine in young people?
Well, I put it a bit more generally. I think education about what used to be called civics, the notion of our civic structures, our political system, and our wider system of government, the three arms of government, how they interact, how they operate, particularly in a federation, as a system of checks and balances. I think education about our civic structures is terribly important in terms of new generations understanding how society is structured and governed. I mean, obviously there's got to be scope for different political views as to policy, etc. But the fundamental core, the structure of governments and the checks and balances. Now, the rule of law, as Sir Owen Dixon said in the Communist Party case, is an assumption on which our federal constitution rests, and our federal constitution, of course, sits above all our laws in Australia. It establishes the High Court, which is the ultimate determiner of the common law of Australia. It also divides the powers between federal and state governments. It provides some explicit protections, some would have been recognised as implied freedoms, but an understanding of those structures, I think, is terribly critical for the ongoing stability. You need an informed society, an informed community to appreciate when those structures are being corroded or endangered or are embattled. Without a basic fundamental understanding, phrases like the rule of law can be bandied around and robbed of any content. I think one important thought I certainly have about the rule of law is that it's important to illustrate what we mean by it by concrete examples, as opposed to just it being a phrase which is invoked by many people in different contexts, etc. To graft concrete examples onto a discussion of the topic, I think, is very important in terms of trying to guarantee that people gain an understanding of what we mean when we talk about the rule of law.
So what kind of concrete examples do you mean when you say that?
Well, for example, I gave an example in my swearing-in speech of the challenges to the integrity of the United States election. We saw that there were a number of court cases brought, 15 or 16 or 17 court cases brought against in various jurisdictions in the United States. Now, there's nothing wrong. In fact, it's appropriate that people have the right to challenge the integrity of an election. There's no difficulty with that. We've had electoral challenges in Australia. But what concerned me, and the reason I gave the example, is notwithstanding that all of the courts ruled, and some very, very decisively, that there was no strength in the assertion that elections in various states in the United States had been stolen, that the system had been rigged, etc. It was a very serious allegation, and it was rebuked. But what concerned me, and the reason I gave the example, is that those rulings seem to just be ignored by, according to newspaper reports and other media, a very large percentage of the United States population. So my concern, the concern to which I drew attention, was that, yes, by all means, have your judicial challenges, but the results have to be respected. And when judicial decisions aren't respected, one has a breakdown in respect for the rule of law generally. I mean, we have an important part of our democracy is that people who take a a minority position. And take another example. We had challenges late last year to the COVID health regulations and the restrictions on freedom of movement and the impact on people's jobs, etc. Now, again, the vast majority, I think, supported, they didn't necessarily like the restrictions, but they supported them. But a minority were permitted to challenge the system. They brought a court case, it was heard, the arguments were received respectfully. As it turned out, they were rejected, but the result was respected. It wasn't said that the court was corrupt or that the court was ignorant or the court was doing the government's work, all of which statements would have been outrageous, but it wasn't said, and there was respect for the decision. What concerned me and again, it's just based on reports, that those decisions of United States courts are just ignored or not given the respect that they are due. Now that is a very concerning matter. Courts aren't infallible, of course, but that's why we have appeals, including ultimately to the High Court. So, and it ties in with that. Then ties in with the importance of judicial independence and the importance of judicial appointments not being politicised. Once judicial appointments are explicitly politicised, as we've seen in other jurisdictions outside of Australia, it's not difficult to see why people then become cynical about decisions of courts constituted by people seen to be appointed because of their political allegiance. Now, look, I have no doubt that a number of the, in a sense, the judges are often powerless in the sense that, in terms of perceptions, if the political process politicises judicial appointments, that's very invidious for a judge who might be standing next to a president or an attorney general, where the president says, we expect this judge to do the right thing. I mean, that is the opposite of the independence of the judiciary.
The one question that I wanted to roll past you is the presumption of innocence. In the age of social media and many issues, legal issues being hyper politicised, do you think that the presumption of innocence is under attack?
Well, it shouldn't be. It shouldn't be under attack. It's a very significant plank in our society, and it's been so for many, many years. There have been obviously with social media, with some high-profile cases, which I'm obviously not going to get into in any concrete ways. It is important that people not be convicted and besmirched without a proper process. I mean, the presumption of innocence is central to our judicial system, and any criminal lawyer can tell you any number of cases where an apparently strong case has not been made out, where the evidence turns out not to be reliable, even though somebody might think it's obvious that somebody has committed a particular offence. That's the experience of the law, and that's why the presumption of innocence is so important, that people who are innocent are not wrongly convicted. People have to be careful with social media. Reputation, people's reputations is very important, and we have to be very careful that people aren't convicted in the media where there hasn't been a proper process.
In jury trials, there seems to be a conflict between, or a possible conflict between, the desire for, or the need to provide a fair trial and the need for prompt resolution of criminal charges. Do you see that, are you concerned that the growth of pretrial publicity in high-profile cases is putting the judiciary in a very difficult position?
Oh, well, look, the courts are very vigilant to ensure, so far as they are able, a fair hearing. And there are procedural mechanisms by which judges strive to maximise the prospects of a fair trial. Obviously, with some notorious cases or cases which do attract a lot of publicity, that becomes harder. But there are, and there can be cases where the prejudice is perceived to be such that a criminal prosecution could even be stayed. Now, that's an extreme remedy. It'd be very exceptional, but that ability is there for parties to, or defendants to, accused to ask for a permanent stay of proceedings, and the court will in each case make an assessment as to whether or not a fair trial is available. There is a lot of reliance placed on the goodwill and common sense of jurors. Judges give directions every day of the week to jurors about what they can and can't take into account. And in a sense, our whole criminal justice system proceeds on the assumption, the good faith assumption, that jurors will abide by directions given by the court, given by a judge conscientiously, that they will conscientiously take into account the directions about what they should or should not have regard to. It's of course, we can't completely guarantee that extraneous considerations, adverse press, etc., will not intrude, but certainly criminal judges are very experienced and on a regular basis seek to give directions to juries which are calculated to maximise the prospects of a fair trial.
Look, on another matter, one of the excuse me, doctrines that underpins the rule of law is that the law be known and accessible. The Law Reform Commission federally has identified a series of problems with corporate law, the massive scale of the law and the complexity of it. Are there areas of state law that you're concerned about that have become too complex to be readily understood?
Look, I think by and large, state legislation, I'm talking about New South Wales legislation with which I'm most familiar, is, as I say, by and large clearly drafted, and we don't see in New South Wales, again, this is a generalisation, but statutes of the same length and complexity that one sees at the federal level. I mean, the tax legislation, the corporations legislation at the federal level is extraordinarily complex and lengthy. But in terms of the courts, what you say is right. The task and challenge for judges is to write clearly. Of course, a judgment explains in the first instance to the parties involved who has won and who has lost, but most importantly, why the party that has lost has lost. That's the objective of any judge in writing his or her reasons for judgment. When it comes to appellate judgments, where the audience is likely to be far more than the particular parties, obviously you have the same aim of clarity, but insofar as an appellate judgment is stating principles, dealing with principles of some complexity, again, the challenge for the court is to express itself in an accessible way. And that's certainly what I have strived to do in the judgments I've written over the last 3 years, and what my colleagues on the Court of Appeal and the Court of Criminal Appeal strive to do. And I think with a large measure of success. We also have, under Tom Bathurst, and I will continue it, issue with each appellate judgment a judgment summary, which seeks to give an accurate, accessible description of the facts and the issues in contention. That's partly designed to facilitate accurate reporting and provide a more digestible description of the case. It doesn't form part of the judgment, but those judgment summaries and headnotes are typically settled by the judge or judges who've written the decision. So that's part of the process of making the judicial side of law and statements of the law accessible and more readily intelligible for members of the public, for the media, for law students, for other practitioners.
One of the other points that I wanted to run past you is the model litigant rules.
Yeah.
We've got these popping up all over the place in various jurisdictions, but they're not enforceable. Would you like to see these rules enforceable in civil litigation involving government agencies?
Well, my experience to date with the model litigant rules, my experience both when I was a barrister and in court, is that government agencies generally take their responsibilities very seriously, and of course the legal practitioners in government agencies remain officers of the court. They're admitted lawyers and they have their obligations as solicitors or as or within the DPP, for example, as advocates, and they're conscious of those added responsibilities. I'm not conscious of any major problem in terms of the adherence to the policy, and the court's expectation, obviously, is an understanding is that those policies are adhered to. They're not rules which are imposed by the courts. They are policies of the agencies, so it's really not. So that they're different to ethical obligations, which are understood to apply to all legal practitioners, which are essentially an implicit condition of practice. They're valuable. I think they're valuable, but I think the risk of any move to make those obligations enforceable is that one would just generate a whole satellite sequence of litigation where there became litigation about whether the model rules have been complied with in a particular case, for particular purpose, I don't think that would be actually a salutary development, and it would invariably delay the progress of the particular cases involving a government agency. I mean, don't forget, a judge managing a case in which a government agency or entity is involved has the carriage and the conduct of the management of the preparation of the case. So if there is default, a judge won't take any different or more generous view because the agency in question is a government agency. If the process is being slowed down, if procedural directions are not being complied with, if discovery is deficient, etc., a judge tasked with managing a case towards hearing will ensure that all parties, including any government agencies involved, comply with the court's expectations.
Look, just to finish up with, at the moment we've got the rise of authoritarianism internationally.
Yeah.
The rule of law, the purpose of the rule of law is to prevent that domestically. Do you think that enough people understand that the principle of the rule of law is the thing that sets us apart from authoritarian regimes?
Look, I think this is why explaining the role of the rule of law, which at its core is the antithesis of arbitrary rule and the arbitrary exercise of power. I think explaining the rule of law in those terms is very important in the context of contrasting our society and our community with the examples of authoritarianism which we are seeing on the rise. I go back to really what I said at the outset. It's something that simply can't be taken for granted. And something, it's a value which needs to be understood by the sort of young people coming through schools and universities who become as voters and adults a critical part of our democracy. So that's why there needs to be, in a sense, not only constant vigilance, but strong educational initiatives taken to make sure that an abstract concept is understood to have very concrete ramifications. That really is, I think, the challenge for the rule of law. Lawyers and people concerned with the health of our democracy have a good understanding, but it's an abstract concept. It's got lots of it operates at all sorts of different levels, and the important challenge is to translate the abstract into the concrete, so that it's with a concrete understanding of why it matters that I think is the challenge for those concerned to ensure that our society remains as we would all wish it to be.
That's a good note to finish on. We've been talking to Chief Justice Andrew Bell, the new Chief Justice of New South Wales.
Thank you.